persons on the before the Honorable Justice of the Appeals Court, now sitting in Boston, foreign within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today on the panel are Justices Hodgens and Allen. Will be the panel for all of the cases today. Just as you all know, having been here before, most of you, if not all of you, each side gets 15 minutes. You needn't use all of your time. We have read everything. We do not entertain rebuttal. My best advice is to get right to the point. With that, I'll call our first case, 25P 720 Commonwealth versus Milan. Mr. Osborne.
Good morning, Your Honors. My name is David Osborne, and I represent Michael Milan, the appellant in this case. Mr. Milan has raised three claims regarding his convictions for disseminating harmful material to a minor. And I would like to focus today on just the first claim. I think the other two claims can rest on the briefing. There are two parts to the first claim, which involve the indictment here, and there are 6 indictments, but they're all the same language, so the issues are all the same with regard to all the indictments. The first issue is that the indictments did not, well, there's different ways to view it, that it did not charge a crime or it did not allege conduct that was criminal. The indictments charged that Mr. Milan disseminated harmful material to a minor, knowing it to be harmful, or he possessed such matter with the intent to disseminate to a minor. But this language from the indictment was taken from an outdated version of the statute. The statute is General Laws, Chapter 272, Section 28. And it's almost verbatim from an old version of the statute. Since 2011, Section 28 has punished persons who disseminate to a person he knows or believes to be a minor any material that is harmful to a minor, or has in his possession such matter with the intent to disseminate to a person he knows or believes to be a minor.
Counsel, you rely on this Palladino case.
Yes.
And I agree the language in that seemed to favor your position, but wasn't that abrogated by Commonwealth v. Doughty?
No, it was not abrogated by Commonwealth v. Doughty. In Commonwealth v. Doughty, the SJC clarified that when there is an issue with when there's a defect in the indictment, that does not remove jurisdiction from the Superior Court. Because there's been a lot of confusion, there's different language back and forth about whether it's a jurisdictional issue or it's a failure to allege a crime. So there was just a clarification, but Commonwealth versus Palladino remains good law today.
But didn't it also say all you need is a reference to the statute, which we do have here, so that overcomes the...
No, it did not say that exactly, Your Honor. What it said was, and I will concede, Your Honor, that there's been a lot of confusion about what exactly an indictment has to plead, because I think if you go back years ago, every court seemed to say, you have to plead all the elements of the crime. And there seems to be some
They've backed off on that, though.
Yeah, they have backed off on that. I agree, Your Honor. But
but to add to Justice Hodgens' point, and Doughty says that defects in the indictment are not jurisdictional.
it does, and
so wait. So if it's not jurisdictional, and this was not raised below, why isn't it waived under 277-47A?
Oh, it's not, because it's also, we not only allege a jurisdictional issue, but also the failure to allege a crime. And that statute
I see that as a separate argument, though.
Well, it's part of our argument. We raise it in both ways. So we have pled it as both a jurisdictional argument and as a failure to allege a crime. And the Commonwealth doesn't object to that. I think the Commonwealth concedes.
I understand, but what they do say is that The SJC and Jones in 2015
Yes.
said that this prior language implies a scienter element that makes it constitutional.
That's correct. That's correct.
So it's not unconstitutional.
Well, I don't think the claim here is not that he was charged under an unconstitutional statute.
You mentioned it several times in your brief, though.
I'm sorry?
Several times you mentioned Judge Zobel's decision.
Yes. Well, that is to explain the importance of the scienter element. And this gets us to the Palladino issue, Your Honor. The scienter element was critical to its constitutionality. The statute, what Judge Zobel found, and what the SJC found in the Jones case, was that without the scienter element, the statute impinged on First Amendment rights.
But the SJC said it's implied in Jones.
Yes, it did. And that's how it...
So we answer to the SJC, not to Judge Zobel.
I agree. Your Honor, that was... my references to Judge Zobel's opinion was simply to explain why the legislature in 2011 amended the statute. It wasn't to say... the argument here is not Mr. Milan was convicted on an unconstitutional statute. The issue here is whether the indictment sufficiently alleged a crime. And without that scienter issue, which was necessary in order to ensure the constitutionality of the statute, I think we'd all agree that without scienter, it's not constitutional. It violates the First Amendment. That's what Judge Zobel found. That's what the SJC found, and that's why the legislature amended the statute between Judge Zobel's opinion and the Jones decision.
In our Erickson case, which you don't cite, we said even under the prior version of Section 28 requires the defendant intends to disseminate prohibited material to a recipient whom he knows or believes to be a minor.
I'm sorry, could you repeat that, Your Honor?
It includes the language, the idea that the argument's missing here. Erickson said under the prior version that it is included.
It's not included. No, and I do want to, that is a very important point, Your Honor. There's, the Commonwealth does cite to Erickson, and it has misread Erickson. In fact, I have Erickson here. And if you read Erickson...
You wrote a reply brief, but you didn't mention it.
I didn't, Your Honor. You're correct, and that was an oversight on my part. I should have mentioned this. But I'm pointing out now that in Erickson, that was not a dissemination case. That was a possession case. And the same is true for the other case the Commonwealth cites, BELIS. Those two cases that the Commonwealth cites for this proposition that it was always in the statute, first, it doesn't make any sense because you can read the language of the statute. It's not in there.
Oh, it's implied.
Well, it was implied in 2015, but it doesn't really matter that it was implied or not. The important issue is the legislature, that is the current version of the statute. That is what is required to be pled, and it was not pled. And in the Erickson case and in the BELIS case, both of those cases were possession cases. If you go back and look at it, you'll see that they do not involve dissemination. The convictions were for possession. And yes, possession does require and would permit you to prosecute somebody for disseminating materials, harmful materials to a minor, even if the person you disseminated it to was an undercover police officer who was an adult. I agree with that. That is a correct statement. But that is under possession, because possession only requires the intent to disseminate. It's not dissemination. And in Mr. Milan's case, although the Commonwealth, the grand jury did indict him for possession, that was dropped out completely from the trial. There was no possession charge that was presented to the jury.
When did the legislature add the language knows or believes to be a minor to the statute?
It was added in 2011, and it was as the Jones case points out, it was in direct response to Judge Zobel's decision.
Okay, and the indictments here were what date?
The indictments here were 2020, or 2020.
2021? 2021. So the indictments referenced the statute that had been amended a decade before. Why isn't that good enough?
That's not enough, Your Honor.
Why not?
Again, this goes back to your issue about Palladino.
Because it says it right here, in the Doughty case, it says, in view of the statute's express delineation, in this case, of the overt acts that were at issue, the indictment was not required to restate these overt acts. Provided there is fair notice of the crime charged, it is not necessary for the Commonwealth to set forth in the complaint or indictment every element of the crime.
That's
Why
correct.
doesn't that control this
That
case?
is correct, but remember, Doughty is not the same statute that we're talking about here.
But the principle is the same, isn't it?
Well, in Doughty, here's what the court said in Doughty. What the Doughty court said was there was an attempt to burn a dwelling. That was the charge, and it's clear that there was a clerical mistake in the indictment. The word dwelling, literally just that word, was dropped out of the body of the indictment. And what the court said was, when you read the indictment in its totality, you have all the elements you need. It says, and the reason is because the word dwelling is in the caption of the indictment. So that is different from our case. You cannot read these indictments in their totality and find the missing scienter element. The scienter element just is not pled at all. And so Mr. Milan is led to believe that he is being prosecuted for disseminating material to a minor when there is absolutely no allegation that he did so. In fact, the Commonwealth concedes that there was no evidence before the grand jury. And I would like to raise one other thing, Your Honors, which I do address in my reply brief, but I want to make it crystal clear. The Commonwealth says, well, there's no double jeopardy problem here, because I think Your Honors may recall that there's a double jeopardy test that you apply when you have a claim of a constructive amendment. And the issue is whether or not it was an amendment as to form or an amendment as to substance. Form is okay, substance is not. And the Commonwealth says, well, you apply a double jeopardy test, and if it doesn't violate double jeopardy principles, then it's okay to amend an indictment. And the problem here is that when you look at...
If he can be acquitted on this indictment, he could not be recharged with including the belief language?
Yeah, so let me make sure I'm getting this right. So if you
got it backwards.
Yeah, maybe I did do that. I'm sorry, Your Honors. It's if you acquit on the original indictment, and you can you be reprosecuted on the theory of the amended, based on the amendment?
And if you can't, then it's form, not substance.
And if you can't, then there are different crimes, and that's correct. But it's not mandated. It's not a mandatory test. That's one point I point out in my reply brief. But I want to get to the most important issue here on this question, which is the double jeopardy question, because there is the Commonwealth says that there's the reprosecution that doesn't pass there's no problem under the double jeopardy test. But when you go and look at the grand jury minutes, which the Commonwealth provided in its supplemental record appendix, you'll see that the grand jury was never told what the elements of the crime were. The only law that the grand jury had...
Do you make this argument in your brief?
Yeah.
Where?
No, it's in my reply brief, Your Honor. It's in
Oh.
response to the Commonwealth's point about double jeopardy.
So you raised it for the first time in your reply?
Well, I'm responding to the Commonwealth's double jeopardy argument. Because they say that there's... And again, this is...
Well, let me ask you this, Mr. Osborne. If we find this indictment is defective, is the Commonwealth, is it appropriate, or can they re-indict him with the proper language?
Well, there might be a statute of limitations issue. This is...
What would relate back?
Potentially. I haven't gotten that far. But certainly, what we're asking for, the relief here, is dismissal of the indictment and reversal of the convictions. I think it's up to the Commonwealth to decide whether it could re-indict him for that. But
Be careful what you wish for.
well, We'll take it one step at a time, Your Honor. But with regard to the double jeopardy point, the grand jury, we have to go back to the grand jury and what the grand jury was presented with. And this helps to understand why the indictments are flawed and why it's important that there's no scienter element in there. Because this might be a different case if the grand jury, if the grand jury prosecutor had presented the grand jury with the statute and said, decide whether this evidence comports with the statute. And so it might be a different case because then the grand jury might go, well, you know, there's no evidence that there was actually a minor involved here, but he did disseminate to somebody who was posing as a minor, and the statute seems to permit that, so we can indict him for that. That's not the case. The grand jury had no information about that element, that scienter element, that exception. So,
I'll leave it there, Mr. Osborne.
all right, thank you, Your Honor.
Ms. Jiang.
Good morning. May it please the court, Kristen Jiang for the Commonwealth, and I'm happy to jump right into the indictment issue. I believe that Doty or Dowdy is our best case on this issue. You know, I have no problem conceding, obviously, that the updated statutory language was not incorporated into the indictments. However, the case law is very clear that the Commonwealth is not required to list every single essential element in order for the indictment to be valid. Again, I think Doty is right on point on that. And as I set forth in my brief, even under the prior version of the statute without the know or believed to be a minor language, I believe that this indictment under these facts still would have been appropriate. And I've cited a few cases that support my argument as to that. And I think also I go into detail in my brief as to why there was no unfairness to the defense. There was no surprise here.
I'm sorry. In Dowdy, though, the defect was cured in the indictment itself because the caption said, what did it say? About
The word dwelling.
Yeah, dwelling. Thank you.
Correct,
Yeah.
correct.
But
No, I do agree.
We don't have that.
We do not have that, but we do have a clear citation to the statute. And as I stated, even under the prior case law, prior to the amendment of this language, I do believe these facts would be indictable, even if there's no evidence that there was dissemination to an actual minor. You know, I cited cases in support of that proposition that, and even under Jones, the SJC has read a scienter element into the statute, even though it was not present previous to 2011. And I would contrast this case to others where there was absolutely a notice problem and where the evidence at trial came out much differently than they did at the grand jury stage, where the defendant was indicted on one crime and after the trial, whether via the Commonwealth's evidence or the judge's instructions to the jury, that crime completely changed at the conclusion of trial. Here, the Commonwealth's theory was always the same. There was no surprise. We were never alleging that there was dissemination to an actual minor. The evidence before the grand jury was very similar, if not exactly the same, as what was brought before the trial. So for all those...
What do you say about Erickson?
I believe that Erickson is still controlling here. I understand my brother's point that it's a little bit different in that you know, these two different types of conduct are both included under the statute, but I still think it applies. The way that the court was reading that scienter element into it, it's clear that that's how courts were interpreting the statute, even before 2011 when it became explicit.
See, in Erickson, there was actually a minor.
There was.
And then the police took over the account opposing.
Yes.
Does that make a difference?
I don't know that it does. I mean, in that case, it's a little bit different because I'm trying to articulate what's in my head. I don't know that that makes a difference necessarily in terms of reading an intent element into the statute as it was written before. As I said, I can see that it's a little bit easier to see it, as my brother pointed out, when it's charged under the you intended to disseminate to a minor, but you were interrupted. So I can see you can get there a little bit easier under those circumstances, but I don't believe that my case, it would have been inappropriate to charge this case pre-2011 under the way the statute was written.
Was there anything here that would indicate the defendant was unable to prepare his defense based upon what was stated in the indictment?
I don't believe so. I think everybody was very, excuse me, everybody was clear that this was what the evidence was. We were not alleging that materials made their way to an actual minor in this case. So I don't believe that the defense would have been different. You know, in fact, the defense was, I thought I was speaking to an adult, and in fact I was. So no, I don't think the defense would have changed at all. If you know, the statute was recited precisely as it should have been in the indictment. I don't think anybody was confused as to what our evidence was going to be.
Does scienter include knowledge?
Depends on the crime, I believe. Yes. So here, the know or believe to know language, it was explicit after 2011. It was implicit pre-2011. So yes, I think in both cases, you have to know or have, you had to either know for sure or there's, you know, a reasonable person would know that this person was a minor.
I'm glad this case wasn't on my first year crim law exam.
Yeah, it's a head scratcher. I will concede that. If I'm happy to answer any other questions, but otherwise I will.
Thank you both. Your briefs were
Thank you very
excellent.
much.
Our next case is 25P22 Commonwealth versus Martinez. As you know, this case is partially impounded. Please don't use the victim's name. Ms. Siddle.
Good morning. May it please the court. I'm Megan Siddle on behalf of Julio AVALOS Martinez. The court should reverse the judgment below because Mr. AVALOS Martinez was deprived of his strongest argument when he was not permitted to elicit testimony about why the complainant here received attention at the time of her first complaint. Mr. AVALOS Martinez should have been allowed to tell the jury that the complainant received attention because another student had alleged that she had hit her. For two reasons. First, the purpose of the first complaint doctrine is to give the jury as complete a picture as possible to assist its evaluation of the complainant's credibility. And second, the confrontation clause requires that Mr. AVALOS Martinez be given a fair opportunity to explore the complainant's.
Both leaves the judge with discretion to control the content, though, right?
Yes, that's correct.
So wasn't the point of her getting the detention and the theory of the defense was that she feared when she went home she'd be physically punished by the defendant, and that was going to occur regardless of what the detention was for?
I think that the defense was arguing that the degree of fear and the severity of that potential punishment would have been higher, or the jury would have understood it to be higher if the jury had known.
Did the victim disclose that to the guidance counselor?
The victim disclosed that her father had hit her with a belt to the guidance counselor?
Did the victim disclose that if he knew I hit another student, it would be more severe punishment?
No, I don't believe that she did. I think that was the defense theory, was that that would be her natural inclination, that it would be a more severe punishment if it was a more severe allegation. Because detention can cover a wide variety of conduct. It could be that she was late for class, and but hitting another student is something much more serious that I think anyone any child would be much more afraid of their parent learning about.
But doesn't it only matter what was in the mind of the child? So in her mind, she testified on direct that she was scared about the defendant's reaction to the detention, and even on cross, she acknowledged she was upset, cried over the detention, and feared physical discipline. Isn't that enough?
She does testify to that effect, but the jury wouldn't have fully understood how afraid she could have been. I mean, the point of the defense was...
But she said how afraid she was.
She said she was afraid, yes.
So why isn't that enough?
Because I think that...
Makes the point, doesn't it? That's the point that the defense wanted to make, that she was fearing this discipline, right?
So I think that the defense was faced with the real challenge here because the complainant had reason to be afraid of her father.
It's not really the complainant. You realize that. The police officer who fills out the complaint is the complainant.
Oh.
So you can call her the alleged victim, you can call her by a pseudonym, but she's not the complainant.
Okay. I apologize, Your Honor. My client's daughter was potentially afraid of going home earlier than the detention incident. She had reason to want to be removed from the home earlier. You know, she told the jury that she wasn't happy that her father wasn't sending her mother enough money. She was, you know, obviously unhappy that she had been physically disciplined, that she was having to do chores at home. She was afraid of walking to school. So the defense was faced with a challenge. They had to tell the jury why she was specifically had a reason to fabricate a sexual abuse allegation on this occasion. And the force of that argument depended on the severity of the potential punishment that she was facing. And the defense wasn't able to fully express that point.
I thought you told us there's no evidence that the severity varied based on her conduct.
Well, she didn't say that the severity would
Did someone else say it?
No, but I think that would be a fair inference for the defense to argue to the jury.
So without an evidentiary basis, and we're reviewing for an abuse of discretion, how does the judge's decision to limit what he deemed to be a collateral matter outside the range of reasonable alternatives when it didn't affect the overall defense strategy that she fabricated this to avoid being punished?
I think it did affect the overall defense strategy.
How is it outside the range of reasonable alternatives?
Because I think it took off the table the primary force of the defense argument.
But the argument was that she fabricated this so she would not be punished.
Correct. Yes. And the strongest version of that argument for the defense was that the alleged offense that the daughter had committed was more severe than a typical detention might be.
What about the issue of what really happened? Because wasn't there a factual dispute as to whether there was a striking or a pushing or a shoving, and whether it was self-defense and who was the first aggressor and so forth? And didn't the judge have legitimate concerns about, all right, you know, we're gonna unpack all of this in front of the jury where there's not a dispute as to what was on the mind of the victim at the time, that she did fear discipline?
Yeah, so I think there was some slight disagreement about what might have happened. The Commonwealth acknowledged that the defense had a good faith basis to argue that the allegation was hitting. The Commonwealth, I think, described it as a shove, and the defense said they're happy to call it a shove. That would have been fine with the defense. They could take that dispute off the table. And the truth of the allegation wasn't important to the defense. What was important to the defense was what was in the mind of Mr. AVALOS Martinez's daughter at the time. So that was the focus, and the defense wasn't planning to go into the merits of the underlying allegation. So if there's no other questions, I'll turn to the issue of the expert testimony. The court should grant Mr. AVALOS Martinez a new trial because the jury heard inadmissible expert testimony. Expert testimony about delayed disclosure is inadmissible because there was no delayed disclosure in this case, and such testimony would therefore not be of assistance to the jury. The disclosure here took place 2 days after the incident that was charged.
But why isn't that puzzled me when I read this in your brief? An incident occurs in a bedroom. Her brother's outside the door.
Yes.
She stops the incident from progressing further and leaves the room. Says nothing to her brother, And then moments later, her stepmother walks into the room and says nothing to her. And it's not until days later that this all comes out. That seems to be a delay.
It certainly isn't instantaneous. I
So
acknowledge
if it's not
that.
instant, it's delayed, isn't it?
Well, the issue here is whether it's a delay that's beyond the jury's comprehension. It is a delay of 2 days, no question about that. But is a delay of 2 days something the jury couldn't understand? I don't think so in this case, because this is someone who was new in this household. They'd only been in the United States for something like 2 or 3 months at the time of this incident. Her stepmother is obviously, in a relationship with her father, not an obvious person to disclose to. So it's not surprising that a child would wait a couple of days before disclosing to a neutral adult at school, as opposed to on the spot immediately at home, when the person she's reporting is the person she's dependent on, who's bringing in, who's supporting her and who is providing her with shelter. So even if there was no delayed disclosure here, Dr. Block's testimony was prejudicial to the defense because it supported the complainant's credibility in other ways. And I'll just reiterate, this was a fairly close case. This was a case where there was no physical evidence. There was the only people in the room at the time of the alleged incident were my client and his daughter. Her brother's testimony didn't strongly corroborate her testimony. There were a number of differences between her testimony.
Mr. Marshall catalogs quite a few cases where Dr. Block's testimony was deemed proper. What's different about this one?
I think the difference is that there was not a material delay that needed to be explained in this case. The substance of...
You and Justice Hodgens just had an exchange about that required some argument to explain the delay.
Mm-hmm. So I agree there is a delay. In my view, it is not a delay that's sufficient to require expert testimony.
And you point to the public, a lot of public exposure of child sex abuse cases in the news, but I don't understand how knowledge of child sex abuse would necessarily imbue them with a necessary sophistication or an inherent sophistication to appreciate the nuances of a delayed disclosure by a child victim.
Well, I think it's just not surprising to the public any longer that children would delay disclosing sexual abuse, sometimes for a very, very, very long time. And
I've been around for a long time, and I remember back around 2005, the SJC was trying to determine what do we need this fresh complaint stuff for anymore? The jurors are sophisticated enough to understand this. They don't need this. They have excited utterances, and they have prior consistent statements. And the SJC asked whether they should do away with it. And then, you know what? They came up with the first complaint rule because they decided that the public is not that sophisticated after all. And they do need expert testimony, especially in a child sex abuse case.
I think that's true. That was a while ago, and that was before some of the...
So I said I've been around a long time.
I'm sorry, I didn't hear that.
I have been around a long time.
All right. Well, before moving on to the prior bad act issue, I'll just point out one issue with the prejudice from Dr. Block's testimony. The Commonwealth used that testimony at the very end of its closing argument to bolster the complainant's credibility by arguing that the fact that her brother denied being sexually abused didn't mean that she wasn't telling the truth when she said that she had seen him be abused. And so this was testimony that the Commonwealth was able to use against Mr. AVALOS Martinez and made a difference in this case. And finally, the court should also grant Mr. AVALOS Martinez a new trial because the verdict was tainted by inadmissible and highly prejudicial prior bad act evidence. And I think I referenced two particular prior bad acts specifically in my briefs. The allegation that her father kissed her genitals when applying a medicinal cream, which was admitted by the trial court. And then another piece of evidence where the witness went a little bit further than the trial court allowed.
The judge struck that testimony, right?
That's correct.
And gave a curative.
The judge instructed the jury to disregard it.
Right.
I think the judge had some concerns in the moment, though, so that the response that the judge made was, we're only talking about conduct that took place here in the United States. I think highlighted for the jury that the testimony that had just been sort of blurted out referenced conduct that took place longer ago.
He revisited it in the final charge, too.
I don't recall him revisiting it specifically. There wasn't a specific prior bad
But
act.
struck testimony is not evidence.
Yes, that's correct. That was in the final jury instructions.
And we have to presume that the jurors followed the judge's instructions.
That's true, although I'll note that in this case, the judge was particularly worried that these kinds of allegations were allegations that would be very difficult to overcome. So for example, in the final pretrial conference that took place on February 27th, when the judge decided that evidence about my client's other daughter, who was, I think, 18 months old at the time, would not be admitted, the trial court said, "It strikes me that this is almost a definition of a prior bad act that might invite a jury to convict him as a bad person." And so our position would be that this is the sort of allegation, it's so vivid.
Yeah, but in the trial court, things often look different on appeal than they do at trial when things are going on. And this information is coming at jurors fast and furious, and whether they can absorb it all and absorb it in the way you think they absorbed it is often an open question, because here the testimony was, he used to do that since I was very little, so I didn't, and then she was cut off. Mm-hmm. What did she mean by that? Because she was referring to him putting cream on her and referring to kissing. What's she actually referring to? Well, we really don't know. So, it was ambiguous to begin with, and the judge struck it in any event.
I agree the judge struck it. I'm not sure that I see that testimony as ambiguous, because the cream and the kissing was part and parcel of the same conduct as the complainant testified.
Well, that's
about
how
it.
you view it now,
Mm-hmm.
but during the trial, when the jurors are hearing all this and they're absorbing some of it, when a witness says, well, he used to do that since I was little. Objection. All right, well, that's going to be struck.
Mm-hmm.
How do we know that jurors inferred what you're inferring now?
Well, I
It
think
wasn't really that clear.
The immediate testimony preceding that was that he, quote, kissed my vagina. So that's...
And just prior to that was the medicine, putting cream on her. So
Yes. That's correct. But this testimony is so vivid and so grotesque, I think it would be pretty difficult for a jury to miss it.
Okay. Thank you.
Thank you.
Mr. Marshall.
Good morning, and may it please the court, ADA Charlie Marshall on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. So I'll start where defense counsel started, that being this limitation of the cross-examination. I'll point out, as you noticed, Justice Meade, that this is an abuse of discretion standard. And essentially what this boils down to is where the relevant factor for the victim's motive to lie, specifically related to the initial disclosure, it was her potential punishment for that detention, which was the core issue that needed to be aired in front of the jury, not the alleged infraction for which she received it. And it's hard to imagine a more sufficient looming or severe looming punishment to a child than being physically beaten with a belt. Where that was in front of the jury, I would suggest that that issue, that initial disclosure and the first complaint in its full context was directly in front of the jury. I think the most helpful framework to analyze this potential issue is by looking at what came in attacking the victim's credibility, both on the initial disclosure and just in general. So it was clear on cross-examination that on the day of that disclosure, she got in trouble and received detention. She was extremely emotional as a result of that. For that reason, the guidance counselor, who ended up being the first complaint witness, was called. Prior to the disclosure of the rape itself, the victim had told the guidance counselor that she didn't want the defendant to find out specifically because of this detention, and that she was fearful for how he might react, and that part of that fear stemmed from the fact that she would be physically beaten at home, including the use of the belt. She also told that she was scared of how the defendant would react specifically to the defendant, and it was only after all of that was disclosed to the guidance counselor that she then disclosed the rape. In addition to just that material coming out as it relates to the initial disclosure, she was also crossed on the fact that she didn't like that the defendant made her do chores at home, that she didn't like walking to and from school, which the defendant made her do, that she just generally didn't want to live with the defendant. She wanted to go back to El Salvador to live with her mom. She didn't like the way that the defendant would speak about her mom. She thought the defendant didn't send enough money back to the home. And then there was also this incident where during the investigation portion of this case, she had disclosed some similar behavior between the defendant aimed towards her brother, which the brother then, in his testimony, wholly disregarded that happened. He essentially said that did not happen. Where all of that material came in and was in front of the jury, this was sufficiently aired, both her credibility in general and as it relates to the initial disclosure, and that any argument that that issue wasn't sufficiently aired just because we didn't go into this collateral matter about her potentially pushing another student at school when we had no other basis or any other information on that was not an abuse of discretion. Turning to the first complaint testimony itself from Dr. Block, so I see the defendant essentially putting forward two very contradictory arguments. First, that this testimony related in impermissible vouching, and second, that it was so irrelevant and unnecessary because delay was not an issue. I don't think that those arguments can stand against each other, and I don't think either of them has merit on its own in the instance of this case. So our courts have recognized that this is the general behavior and characteristics, including delay, of children that are subject to sexual abuse is something beyond the jury's common knowledge. And this court has also acknowledged that expert testimony on that aids the jury in reaching a decision and helps them. And specifically, this court and the SJC has found specifically that Dr. Block's testimony. I'm sure this is not the first time that you have seen her name. She is very common, not just in Suffolk County, but across the state in offering this sort of testimony. And as you noted, Justice Meade, I don't see anything about her testimony here that differentiates from any of the testimony that she's offered in previous cases. She didn't know this victim, had nothing to do with the case. Essentially, the only value of her, the most, I'd say, probative portion of her testimony was that the most common form of delay in children is delay. That was essentially the value of the testimony itself. And in terms of whether or not delay was an issue, Justice Hodgens, you were touching on this, but there is no line of demarcation for how much time has to pass before that delay starts to weigh on credibility. And this court should be very hesitant to draw a line of demarcation, especially on this case and the facts of this case. Every single one of those 9 days that she didn't tell somebody about this could very well have weighed on her credibility. And when her credibility was the core issue of the case, where the core defense of this case was to attack that credibility, that she made it up, it certainly was relevant. And again, under an abuse of discretion standard, I think the judge was well within his discretion in allowing that sort of testimony.
So you believe that it's 2 days, you believe it's 9 days, not 2 days? There seems to be disagreement as to how many days it was.
So I believe the testimony is clear that it's 9 days from the rape until the incident at school, which she discloses it to the guidance counselor. I don't know where 2 days comes from. Turning now to the bad act evidence, I want, again, to start with the standard. This is an abuse of discretion standard. And I want to note what didn't come in, because I think it's very relevant what didn't come in, because that strongly suggests that the judge carefully exercised her discretion. I think defense sort of conceded that there was a lot of thoughtfulness on the judge here. Initially, there was some concern that some of this bad act evidence coming in might inflame the jury, but after a full representation from both trial counsels, having fleshed this out a great deal in motion and limb, the judge chose to limit certain bad acts that were alleged to have been committed against the victim's siblings that were very similar in nature, and that there was some reasonable inference that happened in the general time frame. And I think those other bad acts which were excluded, it would not have been an abuse of discretion to even allow those. However, based on a concern that they could potentially overwhelm the evidence presented on the charge incidents, which is the relevant inquiry here, he chose to exclude those and only essentially admitted one bad act that was perpetrated against the victim that was near in time. We know it happened in the 2 months between her arriving in March and the disclosure, in which there was some like and similar conduct, that being the rubbing the cream on her vagina is sort of a guise for aiding a medical issue that she had going on at the time.
Would you agree that the bad acts are not limited by jurisdiction? So in other words, let's say there's a bad act that happens in Rhode Island, that doesn't preclude it from being admissible in Massachusetts, does it?
I don't think it precludes it. I think it's a factor for the judge to consider, including the time and the victim and the conduct itself. There was no real information as to, at least hard information, as to where this cream and kissing incident happened. I think the most reasonable inference was that it happened at the house.
Were the five prior bad acts that were excluded, did those all occur in El Salvador?
So, no, Your Honor, and a lot of as the Commonwealth's motion in lim lays out, it separates and parses a lot of the conduct into 5 or 6, but a lot of it was conduct that was contemporaneous with the rapes itself. It was the defendant's behavior that was, albeit uncharged, was happening at the same time of both of the digital rapes. But that happened, obviously, where the rape happened, that being in the house in Chelsea. None of the prior bad acts that were put forward by the Commonwealth, to answer your question directly, happened in El Salvador. They all happened within about the 2 months. I can't say for sure whether or not the excluded acts against the other siblings for sure happened in Boston or Chelsea or happened in El Salvador, but I think it's immaterial where they were excluded and didn't come in either way. And just in terms of their main value to the case was that it was probative of his sexual attraction towards his daughter, which the case law makes clear that is a permissible use of a bad act in specifically these types of cases. But they also had the tangential value of both combating any potential defense of accident or innocent explanation. And while that wasn't the defense pursued, there was some credible information put forward in the pretrial process for the Commonwealth to think that it might. So there was a statement that the defendant made in pretrial discovery that the only time he ever touched the victim was to check if she was wetting the bed, which I would suggest that's kind of an innocent explanation. And there was, defense counsel represented multiple times that defendant might testify. Up until the very last second when the Commonwealth closed, he was still representing that the defendant may very well testify. The Commonwealth doesn't have to wait until then before putting on its case. Where he may have testified, and that was in pretrial discovery, the Commonwealth was well within its right to get ahead of that, and so it was probative to that. It was also probative to give further context to the delay in the disclosure. Where he was touching her earlier under the guise of aiding this medical condition, that helps give context to the disclosure in that it seems to suggest that she was preconditioned to accept this type of behavior under a more innocent explanation of him trying to help her medical issues at the time. And ultimately, again, the relevant inquiry is whether this single bad act that came in overwhelmed the evidence of the charge. Here it didn't. And I do want to touch on just a tangential issue that's somewhat raised in the defendant's brief, that being the lack of the standard curative or limiting instruction on prior bad acts. I'll concede there was not the standard prior bad acts instruction that we typically see in cases, neither contemporaneously or at final charge, but there was an instruction in final charge.
Was it requested?
It was not. So it was requested by the Commonwealth. When the Commonwealth moved in limine to admit certain of these prior bad acts, both verbally and in the motion itself, the Commonwealth requested a limiting instruction. It seems like the defendant did not. He made no such request. It seems like he probably agreed, but it seems just based on maybe an omission by the judge, just a mistake, it wasn't given. But that is important to note.
Well, it might not be, it's not it's not a mistake by the judge if it wasn't requested, right? I mean, there's no obligation of the judge to give it sua sponte, right?
There is no obligation to give it sua sponte.
And there might be a valid reason why defense counsel doesn't want to pick at that scab, right?
Correct.
Don't direct the jury to that evidence.
Correct, and it also changes the standard given that defense didn't request one or object to one not being given. It makes this a substantial risk of a miscarriage of justice standard rather than just a simple prejudicial error. But there was a limiting instruction given in closing. The judge did say, you must decide this case, or I apologize. So they said something to the effect of, this is an exact quote, "They may not find," instructing the jury, "you may not find the defendant guilty just because they think, or you think, that he did something else that was wrong or something improper." That may not be the standard long instruction that is given, but it conveys the message. And as this court knows, there doesn't need to be magic words given, just simply the message needs to be conveyed. That was adequately in front of the jury. In terms of the mistrial request, I just want to highlight the standard is manifest necessity, whether basically there was no other adequate remedial measure to take when the victim went just a little bit beyond the bounds of what was permitted in terms of testifying about this happening since she was little. There needs to be a manifest necessity that nothing else can cure that. And the case law talks about ineradicable prejudice, essentially prejudice that cannot be removed. This was a single line of testimony that squeaked out in the realm of completely permissible testimony. It was immediately struck. It was immediately, the jury was immediately instructed to disregard in a very, very forceful contemporaneous instruction that is in the Commonwealth's brief. They received that similar and same instruction at closing charge as well. So there's nothing to suggest, especially when our case law says that we presume that the jury is going to follow that direction and that instruction, to suggest that they didn't. And even if there's any concern that they wouldn't have, the testimony itself was not so inflammatory that it would have essentially led to a conviction on what they were instructed to deliberate on, the 3 charged acts, simply because there was just one line that went beyond the scope. And if there are no further questions, I'll rest on our brief.
Seeing none, thank you. Thank you both. We'll take it under advisement. Our next case is 25P451, Commonwealth versus Bellis. Mr. Rasconi.
Good morning, Your Honors. My name is Mike Rasconi. I represent Mr. Edgar Bellis. There are 2 reasons why this court can find that if Mr. Bellis was so adequately advised, he would not have accepted the plea he took in the Dorchester Division of the Boston Municipal Court back in 2013 or 14. The first is you can accept what's in his affidavit, which I would suggest is bolstered by some other evidence uncovered by his current attorney in federal court, or you can just apply logic. A review of that police report, where the police specifically argue that this, not even argue, assert that this is an inventory search, and not just an inventory search, but a legal one, it's clearly erroneous. That's just not the case. They went into this vehicle after arresting Mr. Bellis for a license suspension and pulling him over for an illegal turn, and just start searching the car. The owner of the vehicle is sitting in the passenger seat.
Do we know on this record that the police knew that she was a registered owner?
Although they listed her as a registered owner on page 1 of the police report.
That police report was written 3 hours later.
The Commonwealth cites the Ellerby case. In footnote 10, it outlines the impoundment procedure. And the first line is, it's the responsibility of the arresting officer to find someone who is in apparent, or to leave the vehicle with someone in apparent control, or to give it to someone that can take custody of it. She's the owner of the vehicle. She's sitting right there, and they didn't do that.
But my question was, and I'll add to it, is there anything in the record that the police knew she was a registered owner, that she had a valid license, or that she even represented herself to be the registered owner?
To accept that the police didn't know that she was the owner, you would have to...
No, my question was, is there anything in the record that the police knew she was a registered owner, that she'd represent herself to the registered owner, or that she even had a valid license?
The police do not note in the report that they investigated that issue.
So there's no evidence that the police knew any of that at the time?
I think the inference is that they conducted a traffic stop, and then this court would have to accept that they didn't run the plate, which would have showed the owner of the vehicle, would have shown if there was outstanding warrants, would have shown if the license or the registration was suspended. I think we'd all have to accept that the police just didn't do anything that they do as a matter of routine.
The registration on the car was suspended?
No.
His license?
His license was suspended, yes. The basis of the stop was an illegal turn on Blue Hill Ave. And obviously they ran his info. To find that he wasn't the registered owner, they would have to know who the registered owner was. So I understand the court's point. They don't explicitly say we didn't know she was the owner.
Let me add to it. Does the Boston PD inventory policy, was that in the record?
Yes, it is.
No, was it in the record at the time?
Oh, no, it was not.
Not now?
No. It was argued at the motion for new trial by the Commonwealth, and it's in my filing. It's a footnote in the Commonwealth versus Ellerby, which is a case the Commonwealth cited in their brief. In the police report itself, there was no mention of the inventory policy, no.
You know, your argument, I think, would have some force if the stop happened today. But the problem, as I see it, is we have the Commonwealth v. Oliveira's 2016, which required the police to honor a request for a reasonable alternative to towing, and then Commonwealth v. Gonzalez-Mendez 2020, creating a duty of the police to inquire about an alternative. But this stop happened in 2013. So what was the state of the law back in 2013? If you're saying that the lawyer did something wrong here in obtaining a very favorable disposition, avoiding a mandatory minimum sentence, getting straight probation, what was the state of the law in 2013 as far as inventory?
Well, in
searches?
2005, this court decided Commonwealth versus Bienvenue, which said that a car is not permissibly impounded if someone other than the defendant can legally drive it away. And the policy in effect at the time, which the Ellerby case came out right before, I believe, this stop, I think in 2010 or 11, that has the BPD inventory policy as a footnote in it. So you can look at that footnote that has a BPD policy in and around that time. And the Bienvenue case, those cases, the Oliveira case you cited, yes, that comes after that, but that doesn't make new law. It's clarifying what was basically already on the books. It doesn't overturn anything. It just it reinforces what Bienvenue said. If somebody else besides the defendant can legally drive the car away, unless there are other issues, unless the car is disabled, unless it's leaking fluid, it's blocking traffic, something to that effect, and none of that was noted here by the police, that Bienvenue case is still, that's good law at the time.
That's interesting. I mean, I remember when those cases came out, and they were pretty significant cases for law enforcement at the time.
But those cases don't overturn what Bienvenue says. It's the same principle. They're just, that situation hadn't come up, and now they're addressing these issues as they come up, basically one at a time. The overlying principle is that if there's a reasonable alternative that exists, and for example, as Bienvenue says, if someone other than the defendant can legally drive it away, if you take that and apply the first line of that BPD inventory policy, it's basically saying the same thing. There's another alternative other than just impounding the vehicle. Ms. Pabon owned the vehicle. She's there. There was no reason for the police to just tell her to get out of it just so they could start doing an inventory. They hadn't, it doesn't appear that there's any investigation into that ownership issue whatsoever. And at that point, they knew Mr. Bellis didn't own the vehicle. So they basically just skipped that altogether and just went searching through the vehicle. And as far as, Justice Hodgens, you raised the favorability of the deal. I'm not sitting here telling you that 2 years probation on those charges, especially a concession on some of them and dismissal of some, is not a good deal on its face, but we can't look at these things in a vacuum. Now, if he didn't have this really strong motion to argue, then yeah, that's a great deal. But this, on its face, on just, if you accept everything the police narrative says, that's not a great deal. Not to Mr. Bellis, it wasn't.
I mean, it was your burden to show that had he known about this motion to suppress, even if it was a winnable one, that he would not have pled guilty. And why would the Commonwealth be just as interested in bestowing this deal of the century if they have to go through the labor of litigating a motion to suppress? They're like, this is a one-day offer. Take it or leave it.
Again, I'm not sure that, I don't know that that's what happened.
No, I'm saying in essence, if you were going to put them through the paces on a motion to suppress, they're like, all right, we've lost interest in cutting your guy who has a prior record for drug possession, right? We're going to give him probation, where he was looking at, I think, 3.5 in state prison on being a subsequent offender. Instead, he got probation.
And again, I go back to my point. Yeah, that sounds like a great deal, But that's if we look at it in a vacuum. If you just said as a blanket statement, you know, we're going to offer, before our motions, we're going to give your client the opportunity to reward or to take responsibility, we'll break down these charges. That might be a great deal for one case, but not for this one, where the...
But why isn't it like Judge Coffey said, why wasn't that a gamble?
I think if you look at that report and accept what the police write, that they asked Ms. Pabon to exit the vehicle to conduct an inventory policy, that is just so clear an illegal exit order because the car has to be legally impounded.
I would shy away from the word clear.
I have to respectfully disagree because they're saying it's an inventory search, and yet they haven't demonstrated any of the steps to suggest that they can do it legally. Even something as simple as we asked her if she could drive home.
The inventory policy came in on the motion for new trial.
It was raised by the Commonwealth.
And does that policy state that they can't be, and there's no inventories at the scene of the crime?
I believe the first line of the policy is it's the officer's responsibility to find the person, if there's someone that can take custody and control, to give it to them.
That's a different question.
Right.
Does the policy prohibit inventory searches at the scene?
No. Again, going back to my point, though.
No, I understand your point, and what, I'll return to my original point. We don't know when the police knew that she was a registered owner. And given the state of the law at the time, as Justice Hodgens has illustrated, it wasn't a requirement for the police to make inquiry if she was a registered owner.
And again, I would suggest to the court that we'd have to ignore that they knew that Mr. Bellis wasn't the registered owner. So to know that he wasn't the registered owner, they would have to know who the registered owner was. And the person is sitting there in the passenger seat. I would suggest that that requires some speculation.
Did she file an affidavit in support of the new trial motion?
She did not.
So we don't know what she said, if anything, to the police.
No, and at very least, that warrants an investigation into that issue on the merits. It warrants an evidentiary hearing to determine what the police did or didn't know at the time. I would turn back again, say I know, just based on the motion for new trial and what Judge Coffey's concern was this was a good deal, and this court's already raised it again. It's only a good deal if he doesn't have substantial defense to raise. And the cases the Commonwealth have raised in their argument, Lopez and Cepalonis, those cases are relying mostly on, exclusively, at least with Lopez, a self-serving affidavit with no other evidence submitted by the defendant. That's not this case. We have an affidavit that's bolstered by some other issues raised as far as the attorney at the time, but also the police report itself. Just a cursory review of that police report shows that immediately jumps out that there is an issue that could be litigated. That's a substantial defense. And I believe in the Cepalonis case, they actually had an evidentiary hearing on the issue where they explored an alibi that wasn't allegedly investigated by defense counsel, and it turned out defense counsel did make steps to determine if an alibi actually existed. They determined that was not a viable defense.
Refresh my memory on this now, and maybe it says it in the report, but I don't remember as you were speaking. When the police made the decision to inventory the vehicle, at that point, had they identified who the passenger was?
They're vague on that. They say later identified as Ms. Lacey Pabon.
Okay, so there's nothing in the record to show that they even knew that the passenger was also, and assuming they knew it was a different registered owner, there was nothing in the record to say that the police knew that that passenger was the same person on the registration.
Right, and again, I think that at very least.
And so they wouldn't know if she had a valid license either, because they didn't get her ID, right?
Right. So, but again, that goes back to the issue of this. At very least, should have been explored in an evidentiary hearing. The police leave out a lot, which are very simple things to include. That, you know, if they're going to conduct an inventory search, they better be sure that they're doing it legally. All they have to do is say, we know who the registered owner was, and it's not the person in the passenger seat, or we were unable to locate the registered owner, so we had to take custody and control of it. It's just, I find it very speculative to believe that they just, after likely running the registration before the stop, ascertaining that the driver did not own the vehicle, that they would not somehow have stumbled upon, even by accident, who the owner of the vehicle was. Because to determine that Mr. Bellis was not the registered owner, I believe you have to know who the registered owner is. So again, I believe that at very least warrants an evidentiary hearing.
Do you argue that the judge erred in not conducting an evidentiary hearing in your brief?
No, I did not. But I think in the motion for new trial, I asked for in the alternative to allow a motion for a new trial, an evidentiary hearing on the merits of the matter.
But you don't request it on appeal?
No, but I still think that's an alternative this court can give. And if there's, and I would just also add that the,
Of course, 12, 13 years having gone by, I mean, it would be an extraordinary police officer to remember something that's not in a report.
well, and again, police officers are trained to write things that are important contemporaneous with the events. So if the court has concerns that they might forget things and leave things out, if they're going to argue that they had a safety issue or a reasonable fear of safety, or they thought a crime was being potentially committed or had been committed, that's something that absolutely would have been in a police officer's original narrative. So to the extent that the court thinks that they might forget things that aren't in the report that might be added, I don't think that those can be credited after writing that narrative and just saying we're going in for an inventory policy, we're going in for an inventory search. And if there's no other questions, I'll rest on my hands.
Thank you.
Thank you.
Mr. Marshall, doing double duty today?
Good morning again, and may it please the court, AD Charlie Marshall, again appearing on behalf of the Commonwealth, requesting that this court affirm the denial of the defendant's motion for new trial. I want to start by somewhat saying the quiet part loud and acknowledging what Judge Coffey seemingly already did, which is the near translucent context with which this claim is being brought. So the defendant has moved to withdraw his plea over a decade later after he willingly signed the plea tender form, and only after it was used to enhance the sentence on his federal case. Just for context, and I'm drawing this from the docket in the federal case itself, he was sentenced to 19 years in federal prison with 5 years of supervised release. And my understanding, if he were to successfully withdraw his plea and vacate this conviction, that would be the difference of about 6+ years in the sentencing structure, about 188 months as opposed to 262 months. So I think exploring his claim here and whether or not this is simply an issue of, or an instance of buyer's remorse as opposed to merit, I think it does make sense to evaluate in that context, especially when it's very clear that Judge Coffey was analyzing it in that context and didn't even seem in his ruling to get to the merits of the motion to suppress.
We can consider delay, but it doesn't prohibit him from trying.
It doesn't prohibit from trying, but I think it's especially important to view it in that context when the burden here is entirely on the defendant, and the only thing that he has essentially provided to support that burden is the police report, and I'll get to that in a second, but otherwise just his own self-serving affidavit, which is contradicted by other more objective parts of the record, one being the plea tender form. He obviously checked and signed the portion of the plea tender form about the waiver of certain constitutional rights. So while not essentially dispositive, it is indicative that he did understand these constitutional rights that he was giving up, and also his criminal history, which showed, in addition to prior convictions on like and similar offenses, it also showed that he had litigated a motion to suppress on his prior cases, that being the 2009 case for which he was indicted of, suggesting that he did know that he had this remedy and litigation available to him. It also...
He knew about Mr. Malloy's legal troubles far earlier than when he filed this motion, is that right?
He did, and far earlier than he pled out on the federal case too. So I believe the offense date for the federal case was May 6th of 2016. He then pled out sometime around December 12th of 2018, I believe, or sometime in December 2018. And then he brought this motion for a new trial, which wasn't filed until December 10th of 2024. So even from the time of his federal sentence to the time of seeking this litigation, there was an extensive delay. And based on the guidelines for destruction of records, there may have still been some record of the Commonwealth's file available at the time of his federal plea in 2018. Now, in 2024, it was gone. So all we have is the police report. But I think, again, that delay is significant when we're losing material as the years pass, and the delay is significant. This is the exact type of scenario that is discouraged by this court.
What material are you referring to that would be lost?
So the Commonwealth's case was destroyed after 4 years. So 2014 was when this case was being litigated, so around 2018. There is an indication in the
No, but you mean the Commonwealth's case, what was destroyed? I'm just curious as
So
to what.
notably is the police report mentions that the defendant is only charged with these offenses after Ms. Pavon is brought to the station and gives a recorded interview. Now, I think what exactly was communicated on that recorded interview would have been very relevant at the motion to suppress, and I'll get to that in just a moment. That seemingly may have been available back in 2018 at the time of his federal plea and could have been put forth to the judge to help aid in actually reaching the merits of the motion to suppress, but we can't now because it was destroyed after that 4 years, likely sometime in late 2018, 2019. But turning to the merits of the motion to suppress, which I don't even think this court needs to reach because Judge Coffey was clear that he didn't find essentially the first step of Safarian. He didn't think that this actually fell measurably below the level of a competent attorney or a fallible attorney where this incredibly favorable plea deal was reached. But if this court is so inclined to find that prong, reach prejudice, that's the only time we get to the motion to suppress. And at that point, it's the defendant's burden to show not only the likelihood that he would have prevailed on the motion, but also that the Commonwealth would not have been able to prove that the warrantless stop and search was constitutional. I think those are interrelated, but somewhat separate things. And on the motion to suppress, I think that the defendant wholly misanalyzes the potential suppression issues presented. And I'll apologize because I don't think the Commonwealth's brief adequately lays it out either. The police report provided makes explicitly clear that the exit orders were the results of a potential tow and then the intended inventory search. It is silent as to the justification for the search of the relevant search here, the pocketbook. There is no indication in the record that the defendant has provided that the search of that pocketbook was done pursuant to an inventory search. And I don't think factually there is any argument that it was, where Ms. Pabon got out of the car with that purse.
Did they tell her to get out of the car, though?
They did tell her to get out of the car, so the inventory is the proper lens to view the exit order. But I would suggest it's somewhat moot in terms of her getting out of the car and the observations they make after. If she's going to take custody of this car and drive it away, she would have had to get out of the passenger seat to start with and at least go around to the other side. And again, I'll note what the court notes, that I think the record is unclear that they actually knew this was her car. There's no indication in the record provided that she was actually a licensed driver and could have driven this away. And again, where it's the defendant's burden to put forth the record on this appeal, none of that material is there. So the exit order, it's clear, was the result of the intended inventory. But I don't believe that the defendant has provided anything to this court to raise what he needs to raise in order to litigate a motion to suppress, which is that he had a reasonable expectation of privity in the place searched, that being the pocketbook. The inventory law, going all the way back to the time of this plea, made clear if someone gets out of the car with their belongings, that it removes it from the inventory search. And while the police report is silent as to why exactly they searched Ms. Pabon's bag, I can think of a few reasons based on what they've seen. She was clutching it, she was nervous, she had originally refused to exit the car and wasn't getting out. She's walking with an unnatural gait. She starts acting very abnormally, saying she's going to be sick. She's trying to make herself throw up. If the record had the chance to be developed at a motion to suppress, potentially officers could have testified to the fact that, yeah, they thought that there might be a weapon at play based on her behavior, her movements, and there was some indication in the police report that there was some back and forth movements from Ms. Pavon while they were running the license. And where that record never got the chance to be sufficiently fleshed out, I don't think the defendant has met his burden to show that we, the Commonwealth, wouldn't have been able to rebut his suppression claims and show that there was a valid search.
I guess he would say that if the initial exit order is invalid, everything that flowed after that would be poisoned fruit.
Right, but again, I think that's a moot point where she had to get out of the car, and at least the exit order at that time, as
You're saying she would have had to get out of the car to move to the driver's side and would have dropped the $6,200 in cash between her legs anyways?
potentially, it seems like she was doing a good job hiding it until the officers asked that further question about anything else, and then she willingly dropped it, so potentially not. But again, all these potentiallys and maybes are the result of a deficient record, which does count against the defendant himself, where it's his burden on appeal to make this showing. And additionally, just getting back to the reasonable expectation of privacy. So this court is clear that in order to litigate a suppression motion, in a Fourth Amendment motion, a defendant in every motion expressed needs standing, and that there was a constitutional search in the sense, and that weighs on the reasonable expectation of privacy. They're related, but the court has made clear that they are separate considerations. Here, no doubt the defendant had standing. It's a possessory offense that he was there at the time of the search. That would give him standing to at least challenge it via an evidentiary hearing. But nothing in the record suggests that he had any access, control, or expectation of privacy in that purse.
That Carter is the case? The boyfriend, girlfriend, they search her purse?
So I do have the factual scenario is not abnormal. We do see these stops happen a lot, where there's a car stop with a girlfriend in the passenger who is asked to essentially secrete things. But I also think, getting back to the fact that the record has been destroyed and that there's no longer this recorded interview, the police report makes clear they find the drugs and the cash on Ms. Pabon. There's an indication that she is going to be arrested and charged with these drugs. It is only after she is brought to the station, interviewed at the station, and we don't know what the context of that interview is, but based on the fact that they then charge the defendant with the drugs, I think there is a strong, nearly inescapable inference that the result of that conversation at station was, well, when you stopped us, the defendant said, hey, I have these drugs, put them in your purse, put this cash up your dress, and don't tell anybody, because maybe he knew that he was going to get arrested. I would imagine that had to be the context if they then swapped those charges and decided to charge the defendant. Now, again, we don't have that in the record, but had the Commonwealth been able to litigate this motion, I suggest that there likely would have been some sort of abandonment argument that could have been made if, in that interview, she said what I just sort of represented or hypothesized, that he took his drugs and his money, gave it to her, put it in her purse, where he had no exclusive access or control or reasonable expectation of privacy, and then we could have showed abandonment. He doesn't have the actual justification to suppress that material in her bag. Again, all this goes back to the core issue here of the delay. He got a very extremely favorable plea deal based on his record. He had just gotten a 6-year state prison sentence on this. The docket sort of insinuates or leads to some inference that this may have been a plea in lieu of indictment due to the fact that many of these charges, specifically the ones that would have taken it out of the district court jurisdiction, were dismissed or amended down to allow for a plea. So not only did he avoid the strict penalties in district court, he was looking at potentially, I think, a 3.5 mandatory minimum on the possession with intent to distribute subsequent offense portion. So he got rid of the mandatory minimum, proceeded in Boston Municipal Court. Presumably at the time of this, he had heard that interview that potentially was turned over in discovery, knew if he had listened to that interview with counsel, potentially if counsel came to the same conclusions that I am coming to, based on what I believe that interview likely said, he may have made the representation like, look, I don't think you have an expectation of privacy in that bag. This is a really, really good deal. You get to avoid jail time where you had just done a stint in state prison. I think all of that in context falls well short of the defendant meeting his burden, that even that this fell below the standard and severian of ineffective assistance, nor that he has actually met his showing of prejudice, which would be the substantial defense, which would be suppression, if he can't even on the record here show that he had a reasonable expectation of privacy in that bag to challenge the search in general. So I do think that the suppression issue is being a little misanalyzed, and I don't even think we necessarily need to go into the inventory if we don't find that he has met the burden of showing a reasonable expectation of privacy. But even if we get past that hurdle, which I don't think he's gotten to, and we get to the inventory law. The inventory law at the time was clear that it was not incumbent on police to seek and offer these reasonable alternatives. If one became aware to them at the time, which would essentially include a licensed driver who was the owner of the car who was willing to take it away, then where reasonableness was the standard, it would have been unreasonable not to allow that person to take that car. However, even assuming again that those burdens have been made, that they knew that she was the driver, that she had a license, that it was her car, her behavior on scene likely would have made it reasonable for them not to let her get behind the wheel. She's outside of the car, she's stating she's going to be sick, she's trying to make herself throw up on the side of the road. I think a court would have been well within their rights to find that it was reasonable, even if she was licensed and willing to drive, to not let her behind the wheel of the car. So all of that taken together in full context, I think the defendant has fallen well below his burden here, and especially when looked at the context with which this claim is brought. And if there are no further questions, I will rest the rest on the brief.
Thank you both. We'll take it under advisement. We're going to take a short break. All rise. Our next case is 25P169 SOR 119114 versus Sorb. Mr. Gauthier.
Yes, good morning, Your Honors. My name is Attorney Edward Gauthier. I'm arguing today on behalf of the plaintiff appellant John Doe. May it please the court, Mr. Doe is finally classified as a level 1 sex offender, low risk, low offense. I'd like to first address his claim as raised in the Superior Court that his hearing counsel was ineffective for 2 reasons. One, for failing to introduce a research article on offense-free time in the community that post-dated the previous iteration of the board's regulations that were updated last year, as well as the failure to introduce medical records that would have directly addressed a deficiency the hearing examiner found and applied only moderate mitigating weight to physical condition as a result. The medical records are from a doctor out of North Dartmouth, Massachusetts, dated November 7th, and they specifically address the deficiencies. The hearing examiner in this case stated, I apply only moderate weight to this mitigating factor because no submissions from his medical providers were submitted, indicating any limitations because of his conditions, nor were any prognoses provided.
Which factor, Mr. Gauthier?
This is the physical condition factor. That would be factor 31. And it was given only moderate weight because of a failure to introduce a medical document that was thereafter provided by Superior Court counsel to the court. However, it was not taken into evidence by the Superior Court judge as he denied Superior Court counsel's motion to supplement the record. I will point out that on appeal, we are raising ineffective assistance of counsel for failure to introduce this, which would have cleaned up the deficiency as cited by the hearing examiner in the decision.
Is this the Hansen article?
This is the medical records, Your Honor. It's a letter from an attorney. It's at page 74, 75, and 76 of the record appendix. It essentially addresses, it was submitted to the Superior Court as part of a motion to enlarge the record by Superior Court counsel, who is different than hearing counsel in this case. And the argument is essentially that if the hearing examiner had been provided this.
Yeah, but weren't these documents authored after the date of the decision?
Yes, Your Honor. They were authored after the date of the decision, which is why the Superior Court judge denied Superior Court counsel's motion to amend the record. However, our claim on appeal, which mirrors the claim that was made in the Superior Court by Superior Court counsel, is that hearing counsel was ineffective for not obtaining a letter from Doe's treating physician that would have done the things the hearing examiner specifically identified in the board regulation that were not done. So a hearing examiner is, in this case, able to give only moderate mitigating weight to physical condition because there was nothing from a treating provider that addressed the limitations of the condition or prognosis. Superior Court counsel recognized this failure and raised 2 issues. One, he attempted to get the medical record into evidence at the Superior Court. That was denied, and the judge denied that because the document did not exist at the time of the hearing. However, Superior Court counsel also argued that hearing counsel was ineffective for not procuring this document, and that is the issue we are re-raising.
Doe's daily activities and his medical problems and his incapacity, those were pretty well cataloged before the hearing examiner.
If they were sufficiently cataloged before the hearing examiner would have given the full weight to the factor.
Not necessarily.
But the reason the hearing examiner didn't give full weight to the factor is specifically because hearing counsel didn't provide a letter showing the prognosis and the limitations. The hearing examiner specifically says moderate weight only because there's no letter from a doctor.
What's in the letter that wasn't before the hearing examiner?
Prognosis and the physical limitations. The prognosis.
A lot on physical limitations before, right?
There are a significant number of health issues in this case, and those significant health issues were described through testimony and through medical. And the limitations were described by treating individuals. This is an individual who has significant mobility impairments, requires assistance bathing, getting up, toileting, etc. The issue here was that there was nothing introduced at the hearing prior to the letter of November 7th that described whether this would be going into the future, whether it was chronic, whether it was not chronic, whether it was a passing phase. In the letter from November 7, the prognosis is this will continue into the future and it will affect expected lifespan. Essentially, these are chronic, permanent, lifelong medical conditions that specifically limit the ability of Doe to do all the normal activities of daily living. And without this letter, Doe received only moderate consideration for his significant physical disabilities. And we know that the reason he only received moderate weight was because of this letter, because the hearing examiner specifically says, because we don't have a letter from a treating physician detailing the prognosis into the future, he can only get moderate mitigating weight as opposed to the full weight that he could have gotten if this letter had been provided. The other issue raised in the Superior Court by prior counsel was the research article. And I will point out front that in this case, the hearing examiner gave, quote, full weight to the issue of offense-free time in the community based on the existing regulatory factor that was in effect in 2023. The article that was introduced by Superior Court counsel, the article Superior Court counsel attempted to introduce as part of the motion to expand the record, which was denied, details the science which postdates, the research article postdates the board's existing regulations, detailing how risk declines over time and how an individual who reaches the offense-free time in the community that Doe has is approaching 0 or 1% risk. We're not saying that this is a dispositive.
But I don't want to throw you off, but I'm still stuck on your prior argument.
Okay.
So if we have a hearing and the certain deficiencies noted by the hearing officer, and then the petitioner comes back later and tries to sort of, backfill by addressing those deficiencies, would the examiner be required to credit that evidence? In other words, the medical records that were submitted did not address certain things. So then it appears that the petitioner went out and obtained records, I guess, to try to address those matters. Doesn't that suggest that, well, this was all sort of contrived to achieve a certain result here? In other words, it wasn't important enough to the medical providers to note this information in the first instance. They only did it because a lawyer contacted them and said, hey, we need you to check off A, B, C, D, and E here. Right? So in other words, it might not be that credible now.
So what you're asking me, Your Honor, is does the hearing examiner have to believe Doe's medical provider when he updates? A hearing examiner is given essentially near complete authority within their power to credit or discredit any evidence that goes before them. It would be a judgment call if the hearing examiner were to receive this letter, whether to credit the fact that Doe has a chronic condition. I believe if even a layperson, I think, can look at these medical conditions and find that these aren't going away. Given Doe's age, given the full list of his many medical conditions, I don't think any hearing examiner would say, well, I'm looking at all these medical conditions and the doctor says that they're chronic, but I'm going to find that because the evidence didn't come in prior to the hearing that this doctor is being untruthful. I don't see how a doctor would be untruthful.
Not necessarily untruthful, but it's just not so significant It's not so significant a factor that it's going to be noted in the records. But after the fact, oh, okay, well, you need this for a hearing. Okay, what do you need? Oh, I need you to address this, and this. Okay, here you go. It just seems it's prepared for litigation. It's not really prepared for treating the patient.
Well, everything in a board hearing that comes from Doe's side, or any Doe's side, is all prepared in advance of litigation. Any letters of support, any materials from an expert, everything.
Well, even worse, it seems tailored. It seems tailored for the litigation. So that tends to, I don't know, if I were the hearing officer, I might look at that and say, well, gee, I mean, these really aren't like independent medical records. These are, well, now you're writing this up to try to make a point. It doesn't seem to carry as much weight as if it appeared originally in the medical records.
I believe that the letters that were provided to the hearing examiner at the hearing were similarly prepared in anticipation of this case. So I don't think that we're having a situation where bare medical records were provided that were in the course of treatment. I believe that the materials submitted to the board at the hearing were also made in anticipation of litigation. I can't speak to what a hypothetical hearing examiner or what this hearing examiner would do. From a legal perspective, all I can reiterate is a hearing examiner is always free to credit or discredit a witness. So I don't know what this hearing examiner would do with this evidence in a hypothetical subsequent hearing, or if this was presented. I believe that if this were presented at the hearing, our argument is this should have been presented at or before the hearing, I do believe the hearing examiner would have been constrained to at least address it in the decision and would not have been able to allow only moderate weight based on this letter. And I wholly understand Your Honor's query about the potential negative effect of having this given to a hearing examiner after the evidence has closed. And we, if you look at the timeline, we fully acknowledge that the letter was created after the decision, and the letter essentially sought to correct the mistake that had been made by hearing counsel by not procuring a letter that detailed everything within the board's regulation.
Would you agree that the difference between the information provided at the hearing and then in the future had to do with future prognosis?
Yes. Yes.
But the examiner's looking at the current risk, correct?
That is a very, very good point, Your Honor. So the question has to be, does the prognosis in the future matter? And in a way, because these hearings seek to determine risk and danger today meaning the day of the hearing, whether these conditions would go into the future 10, 20 years really should not matter. So you are right that a hearing examiner may be incorrect by saying, I can't give him full credit for his current physical condition because I don't know what it's going to be like in 10 years. Well, his risk of reoffense in 10 years is not what matters in a hearing. It is his risk today. And for that, the hearing examiner was probably incorrect by putting too much weight. However, the regulation does look at the future prognosis, and I would point out that no petition was filed in the Superior Court to question the regulation, so we are constrained not to do that on appeal. The Doe has fully briefed all the issues that were raised in the Superior Court and has also raised an issue of substantial evidence and arbitrariness.
Your mechanical chest lift was not raised in the Superior Court.
That is correct, Your Honor. That was not raised.
Like Groundhog Day with you and me.
Yes, we do this sometimes. Yes, Your Honor. I will concede that generally on appeal in civil cases such as these, we are constrained to raise those issues that were raised in the Superior Court. And I will concede that issue 1, insofar as it brings up that issue, was not raised in the Superior Court. However, I will say that issues 2, dealing with offense-free time, advanced age, and home situation and support systems, as well as issue 3 with the research article and medical records, were all raised in the Superior Court, and we would ask that you address them in your decision. And if the panel has no further questions, Doe and I would rest on our brief.
Thank you.
Thank you.
Good, Leah.
Good morning. May it please the court. My name is Stephen Killane. I'm here for the Appellee Sex Offender Registry Board. When it comes to ineffective assistance of counsel, I think the first question obviously is whether it was a serious incompetency, inefficiency, or an inattention of counsel at the administrative level in this circumstance. And while that issue was raised at the Superior Court Department, I think one of the kind of challenges for the argument on appeal in here is that Doe fails to meet this relatively heavy burden because, and in part, because the record doesn't support it. We don't really know what the strategic decisions of the prior agency counsel was. As the court has, or your honors have already identified, it's a hard argument, I think, to suggest that a counsel was ineffective before the board where the item of evidence didn't even exist or the item of evidence being proffered didn't even exist at the time of hearing. Now, as Judge Hodgens identified, it's purely, it calls into the credibility even, a doctor's letter where post-hearing and after reading the decision, counsel for Doe at the Superior Court level reaches out for a medical note that identifies a specific physical limitation or a specific prognosis in response to the way that the hearing examiner's decision reads. I would suggest to you that that in and of itself kind of calls into question what kind of information may have been available to prior agency counsel, and it certainly doesn't rise to the level of ineffective assistance of counsel because he didn't have that specific item of evidence. More importantly, I think, is the fact that what is provided in the November 7, 2023 letter from Dr. Gularek, is it really a recantation of what he already provided and is part of the record and as was examined by the hearing examiner pursuant to the November 2022, I think, letter. And specifically, I think that the November, or the 2022 letter in particular, is more characteristic of what you might see in a medical note that might be elicited either for litigation or for whatever purpose, where the doctor in kind of summation fashion says, I'm treating this particular patient. Here is an attachment of a medical record that has a list of diagnoses and medications and that you can utilize or weigh in whatever way you need to. That's what the hearing examiner did here. He obviously gave a pretty robust conversation under Factor 31 to each of the medical diagnoses that were offered as part of the record. And also, that letter was reinforced by the testimony of Doe by way of his affidavit. He talks about many of his physical limitations at the time. And it's also reinforced by the testimony at the hearing from a number of his personal care assistants that talked about the level of assistance that he needed in his daily care. But on balance, if you also look at the affidavit that was provided by the petitioner, he talks about going to meet family and friends out for meals. I mean, it wasn't like this is a situation where he was confined to his home. It's certainly a situation where there were some limitations, and the hearing examiner weighed those limitations based upon the diagnoses that were part of the record and part of the testimony before him. But he was fully within his discretion to give that factor only moderate weight. And I suggest to you that there's nothing part of the record that's before your honors that suggests that a prior agency counsel was ineffective for failing to introduce this subsequent letter. Similarly, focusing on Factor 29, my brother again proffers something that isn't part of the record. So first you have to assume that it's not part of the record, and there's nothing that suggests that giving full mitigation to Factor 29 was error. What my brother wants you to do is suggest that Factor 29 should have this Trump effect, meaning that Factor 29 should be more important than any other risk aggravating factor that might be applicable in a given case. But that's just not the way that the board views Factor 29, and there's nothing in the research being proffered which would suggest that that is what should happen. In fact, the 2019 Hansen and Thornton article, which the board concedes is a very important article, but it's not inconsistent with the underlying research of Factor 29, either as it existed at the time of hearing or in the adoption of the new regulations that the board has. In fact, the findings of that Hansen and Thornton article from 2019 is entirely consistent with the way the board treats offense-free time in the community, and there is certainly nothing about that article which is a dispositive saying that Doe, before the court here, is a non-cognizable risk of reoffending. He certainly had significant offense-free time. I believe it was 18 years at the time of hearing, and that's the reason that the hearing examiner gave that Factor 29 full mitigating weight. The fact that prior agency counsel did not introduce that research article, I don't think is evidence of ineffective assistance of counsel, especially where it's entirely consistent with the way Factor 29 was already going to be applied. It's entirely consistent with the advocacy of Factor 29 to be given full weight, and I would suggest to you—
Give more than full weight.
You can't give more than full weight. Again, there's nothing about that 2019 article that suggests that Factor 29 should be given a trumping weight over any other aggravating factor or in the overall qualitative analysis. And so I don't think that you can argue here that it was ineffective for agency counsel for Doe to not submit that article. And so essentially you touch upon the second prong of ineffective assistance. I think you had to show some appreciable difference that would have happened. Here it's entirely speculative, both with regards to the medical note that was authored after the hearing, as well as this 2019 Hansen or Thornton article. It's entirely speculative about what the hearing examiner may have done with that information, and I don't think that that rises to the level of ineffective. As Your Honor, Justice Meade pointed out, turning to the substantial evidence or the mechanical application of the factors, that issue was not raised at the Superior Court. I would suggest that it's been waived. Nonetheless, I would suggest that there's numerous examples within the decision showing a careful, reasoned analysis of the relevant risk aggravating factors as well as risk mitigating factors. And unless you have any specific questions about those factors, I would rest on the brief.
No, seeing none. Thank you.
Thank you.
Thank you both. Take it under advisement. The next case is 25P703, Department of Children and Families versus Mother and Father. As you all well know, this is impounded, so please use titles, pseudonyms, or something other than actual names, please. Ms. DeFeo.
Excuse me.
Seven and a half.
Yes, Your Honor.
Go ahead.
Are you ready? Good day, Your Honors. My name is Jennifer DeFeo. I represent the appellant mother. Today, we're asking that you reverse and remand the case that was brought up through the juvenile court. There are three specific issues, Your Honors, that need to be addressed, and they need to be addressed in order. The first issue is whether the trial judge properly denied the motion for the attorney to withdraw. The second is whether the judge properly denied the request for successor counsel. And the third is whether the judge properly allowed mother to proceed pro se, where she was not unequivocal in wanting to do so. And the answer—
So the first issue is the motion to withdraw, and the motion to withdraw was not in the record.
The issue is it wasn't available, so I couldn't produce it. But the trial transcript is very clear, Your Honor. It was a one-line motion to withdraw that did not accompany with an affidavit or any reasons. The judge actually denied it on the record.
I don't know what that means, that it wasn't available.
It was not in the docket, Your Honor. I went physically, as I always do in these cases, to look at the file. It was not available. And even if it was and somehow I overlooked it, which isn't the case in my opinion, the judge on the record specifically found that the motion lacked a reason and it lacked an affidavit. But regardless, in order, even if it had been an oral motion, the judge was mandated under the law to conduct an inquiry, and that was very clear in Commonwealth versus Clemens. That case specifically held that a judge must permit a party to advance the reasons for wanting to discharge an attorney. In Clemens—
But you know what, back to this point about the motion, a lot seems to hinge on what's in that motion.
there was nothing in it.
But we don't know but we don't know that.
The judge indicated what wasn't in it, and the judge was very clear that there was nothing in it. The judge
Well, there had to be
stated-
something in it. It had to have said something. And couldn't the parties have put that back together again to say, oh yeah, here's a copy of it, let's agree to this, let's make this part of the record, so the appeals court isn't in the dark as to what was presented?
The judge, Your Honor, you're not in the dark, because the trial judge was very clear on the record that the motion gave 0 reasons for wanting to withdraw, and it gave no affidavit or supporting documentation. That's as clear as you can get.
But
All
how do we know it didn't say, my client wants to represent herself? That
Because-
might be something significant, right?
Because the judge said it didn't say that. The judge was very clear.
Where is that in the record? That
It's
the
in the
judge said, that the
transcripts.
judge said there was nothing in the motion about the mom wanting to represent herself. That's in the record somewhere?
What's in the record, Your Honor, is that the motion stated nothing other than that counsel wanted to withdraw, and it did not contain an affidavit. Even if it did, Your Honor, contain that mother wanted to proceed pro se, which there's nothing to suggest she did. There's nothing in any opposition.
What about her notice of appearance where it expressly said that?
Her notice of appearance was because she was presented with no alternative. She did not file a notice of
Well,
appearance.
where is that in the record, that she was presented with no alternative? Because it says in her notice of appearance, please enter my appearance in this case. Check for myself. That's pretty clear. She wants to represent herself, isn't it?
So the question is, when did she do that? And the answer is, she did it only after repeatedly being told by the trial judge, this is your attorney, take her or leave her. And trial counsel said, I would like to step out with my client and speak with her. And it was only after that, when the judge said, it's your trial counsel and that's it, did she file the notice of appearance. But that still doesn't excuse the judge for his blatant failure to comply with the case law that says the judge must, this isn't a shall if he wants to or not, is the judge has to understand the reason why this motion is presented.
Well,
And
he did
even if
conduct
it's
a
because she
colloquy-
wants,
Excuse
I'm
me,
sorry?
he did conduct a colloquy with her.
So he doesn't conduct the colloquy on the motion to withdraw, nor does he conduct a colloquy on the motion of his denial of successful counsel. The only time he ever asks her why is too late, because at that point, it's when he's doing the colloquy on her request to proceed pro se, even though she says, I want an attorney. So the colloquy came far too late under Commonwealth versus Clemens. The case is cited in Commonwealth versus Clemens, which includes Commonwealth versus Moran. And even if we get past the original motion, the judge also said, I'm not giving you successor counsel. This is your attorney. Take her or leave her. And when he said that, case law, separate set of case law.
Oh, wait a minute, but that was not in response to something the mother said. That was in response to something the lawyer had said.
Which part? I just want to be clear.
About this is your lawyer, because the judge had already determined, okay, you want to represent yourself, and then the lawyer interjected and said something like, well, Judge, I just want to make it clear that she's not looking for another lawyer, and of course there was nothing before the judge at that point saying that, and that's when the judge said, well, just so you know, you do have a lawyer, which was a correct statement.
On the first day of trial, before the mistrial, the DCF attorney called Mother, and the court called her up, and Mother stated, I am not going forward with trial until I speak with a lawyer. The judge asked her, are you refusing to testify? This is a trial transcript 20 to 21. She said, I am not going forward. I haven't talked to my lawyer. So the judge says, you've asked her to withdraw, and I've denied that. You asked to represent yourself, I've denied that. Today is the trial, we are going forward. I think that that's pretty darn clear that this is what she wanted. And the court had to adhere to the case law, which mandated an inquiry as to her why. Because you can't get to an abuse of discretion when you can't exercise discretion without knowledge. So how can the judge say, okay, I'm going to deny this motion to withdraw because A, B, and C, if he doesn't know what the A, B, and C is, which is why Commonwealth versus Moran, which was very harsh, said, I am remanding this for an evidentiary hearing to find out why the party wanted the case, the counsel to be discharged.
All right,
That's
we're
pretty
going to
strong.
leave it. Your time is up.
Oh, wow, that was fast.
7.5 goes by fast. Mr. Yanoff.
Good morning, Your Honors. My name is Warren Yanoff, and I represent the father in this case. Basically, Your Honors, this case is a rush to judgment. There was no option. Father was in a situation where the judge had basically prejudged this case. He even said it during when my client was testifying. He broke and he said, "You're attached to mother." What really is the issue is mother we don't know mother's parenting ability. Mother has not parented, if you look at the record, at the time of trial, for literally 22 years. All her children that she previously had were removed pretty much at birth. She had never had that option. When you look at this case, what you see is a different father. He's had a relationship at the time of birth for approximately 3 to 4 years. There's been no issues. The child was born.
Didn't he want a joint reunification with the mother, though?
Absolutely.
Yeah.
But
she had considerable issues.
I disagree, Your Honor, in the sense that what we know is certain that she was with other gentlemen, other husbands, that were not similar to my client. My client, there's no issues of domestic violence. Mother, at the time of birth of this particular child, there was no substance abuse. There is nothing there that indicated.
She tested positive during the trial.
That was after the birth. The question really has to do.
She was under the influence of drugs during the visit.
And you still have to, at least it's been long known that just because she had, if she was substance abuse, there has to be a nexus for her to show that she's unfit.
There's also domestic violence. There's also mental health issues. There's also stability of housing issues.
Again, where in this record shows that they showed a nexus. They never even tried to see if these people.
So to that point, you don't contest any of the findings. I didn't see that you took any of the individual findings and are saying that there was error, correct?
What I raised in my brief is that of the 14 factors, that those factors were not applicable based on.
My question was, there are no specific findings that you have said there are error, correct?
Because
you're basically saying that the totality of the circumstances or something.
If you look at the findings, which are, I believe, findings regarding the father, there is nothing there that indicates that he's unfit. He parented 3 other successful children. What happened in this case, he was fit.
But you would agree with me that there's plenty of case law that says that if somebody refuses to remove themselves from a relationship where the other person is unfit, that constitutes unfitness. Would you agree with me?
In a different context, Your Honor, and I don't mean to be, I am argumentative, but the issue is, in this situation, given their relationship, where they weren't parenting, we don't know, she seemed to have been able to give birth, she was cooperative with prenatal care and all of that. We don't have a set of facts at the time of birth that would warrant the removal of this child other than her past. But again, in her past, she hadn't parented. We don't know. We have never, there is no evidence in this record that says, other than she tested positive at various times, or they presume a mental health history, do we have a situation in which we have facts, clear and convincing evidence of this couple being unable to parent the child? We don't know how that would have improved. All they did was allow an hour a week to do that. The person who was done by didn't even, the bonding doctor didn't even have the parents interact with the child. This is really a situation where this judge, who had previously presided over her last two children, basically said, you have to leave. The department even said, we would consider you if you separated from mother. The fact of the matter is, they never gave this couple a chance.
Well, that's the point, isn't it? And I think you just said it. You know, we'd consider you if you would separate from the mom. That seemed to be, and I'm sympathetic to the father's difficult position here. It seems that his loyalty to mom eclipsed his judgment as to the welfare of the child, and that's what was going on here. And it seemed to have occurred to him in his closing argument, where he basically said, Judge, I'll retire right now so I can take care of this child. But by then it was too late. I mean, the evidence was in showing quite the opposite, that he was still so loyal to the mom
But
that he was putting that interest first.
With all due respect, he can be loyal to mom. Again, their relationship is not characteristic of her previous relationships. There was nothing that indicated that they couldn't parent, or that he was not strong enough, a better parent, that she improved. We have no evidence in this case that she didn't improve. Notwithstanding, again, we have to show a nexus, whether it's on mental health or substance abuse, to show that she is unfit. No one is to suggest that he was not able and she did not improve after all these years, given the fact that, and they're still together. That's a reality in this situation. The reality is the evidence was of her past, not of her present. She never parented. The last children that were taken, one was born in 2017, one was born in 2020, and they never were with her. We don't know, and this is a total rush to judgment. She may have had issues. We don't know what her current parenting ability is because they never allowed it.
Okay, thank you.
Thank you very much.
Mr. Bellis.
May it please the Court, Jeremy Bellis for the Department of Children and Families. I think a good place to start is with this Court's recent decision in adoption of Doretta, where it reaffirmed that care and protection petitions, proceedings, are distinct from criminal proceedings. And part of the ways that they are distinct is because the focus of the proceedings, the parent's rights, do often take a back seat to the best interest of the child, and that the proper focus is on the welfare of the child. That was at 490, and it is paraphrasing the Supreme Judicial Court in Ilona. They also reaffirmed that parents do not have a right to appointed counsel who adhere to their preferred vision of the case, or to choose who their appointed counsel are.
Is it in the record, Mr. Bellis, why the department asked the judge to revisit the decision of her representing herself?
Beyond what was said when the department's trial attorney did it, which I believe was something to the effect of, we would like for you to do a colloquy. Mother has the right to present her reasoning why. And that colloquy occurred. It was thorough. It established that mother understood, there was knowing. She knew what.
We don't know why the department asked.
Beyond what was said on the record, no, there's no extraneous. I mean, I can hypothesize, I have to assume that because mother asked to proceed pro se and was sort of summarily dismissed, that it would be preferable.
Do you think that there should have been more of a colloquy on the motion to withdraw before they got to that point?
There could have been, but I don't believe it was required to affirm. There was a motion that was, I think, uncontestedly bare bones. It provided no good cause. And then, while it may have been ideal to inquire then, we do know from the later colloquy that there was not good cause. Mother's reason for why she wanted her attorney to withdraw was because she's not representing me right, which goes back to Doretta. It goes back to the case law that was in place before Doretta, that you don't have the right to appointed counsel that adheres to your vision of the case. There needs to be a lack of preparedness, which there was nothing in the record indicating, and the judge specifically said, your attorney that's been appointed is prepared, is ready, has been doing good work. There has to be a general incompetence, which mother tries to argue for the first time in her reply brief, but there is no actual argument of ineffective assistance raised to the appropriate manner, or any evidence indicating that this attorney was ineffective. There's no evidence of any failure to communicate. There's nothing indicating that could support a determination in this record that there was good cause. And so what we do have is that
He did deny the motion, so it's I mean, maybe there's it's through a different lens if the motion had been allowed, right?
Yes, we would be, if we were trying to argue error in the allowance, it would be different, but it was denied. And Olivia establishes pretty clearly that that is acceptable, and it is an acceptable outcome of the denial of a motion for new counsel to then leave the parents with the option of proceeding with appointed counsel or representing themselves pro se. And during that pretty extensive colloquy after it was held, the court learned that mother had represented herself multiple times in criminal matters. The court already knew that mother had herself been in care and protection proceedings before this one, so she knew sort of the stakes at issue. And the colloquy established unequivocally that yes, mother wanted to proceed in this manner. And then when the trial began, there was never another stage where mother said that she wanted an attorney. There was no error.
Are we able to decide this issue of counsel without seeing the very motion that was the genesis of the whole thing?
Yes, although I agree that it would be better to have the motion, because there doesn't really seem to be any dispute that there was nothing in the motion that would have impacted the decision. And sort of regardless of there was testimony.
But I mean, it would be critical if the motion said, Judge, I want another lawyer. That would have been pretty important. Or if it said, Judge, I don't like my lawyer, I can do a better job, I want to represent myself. But we don't know if either of those things were said, right?
That's true. And I guess in the most extreme sense, that would be an argument for affirming the court's decision, that there's not a sufficient record to disturb the decision below. But I think more better, for lack of a better phrase, is the fact that if any of that was true, mother was speaking with this judge on this issue for a pretty long period of time. If mother had said, I want to get rid of this judge, get rid of my appointed counsel because I need a new lawyer and that is what I need, which she did say to an extent, and the judge was able to evaluate that. But then she, after that, had an entirely separate request and colloquy in which she asked to proceed pro se. And the judge was in making the initial decision, looking at a case that was closing in on 2 years old. Children do have a right to permanency in a timely manner. We go back to Doretta. The child's rights are of more importance to the parents. And so if it is in a gray area where maybe we're not sure, looking at the age of the case, looking at the fact that this is the child's chance to get permanency in a timely manner, that can supersede in child welfare petitions in the way that it cannot, or similar issues cannot, in criminal matters. So We're unfortunately here with a less than ideal record of what happened, but we do know what mother asked for, when she asked for it, and what her statements were. And by the time mother was allowed to proceed pro se, she was unequivocally, knowingly, and intelligently asking for the ability to proceed pro se and represent herself.
Let me ask you about the judge's findings. There were a couple points where he indicated that the father did not address mental health issues. I didn't see that there were any mental health issues related to the father. Did I miss that somewhere in the record?
No. Father's sort of failings independent of mother were primarily his lack of providing stable ability to provide stable housing. What the department's focus was, it's laid out in the action plans and it's laid out in its testimony, is that father was insistent that he would co-parent the child with mother. Mother did have significant mental health, among other issues that I don't think we really need to drill in too deeply on. They're well documented, they're well established. And so the department wanted father to understand what came with co-parenting with mother, the ways in which co-parenting with mother would expose the children to volatility in her mental health, volatility in her behavior, her ongoing relationship with her two abusers, and actually abuse victims, because she also was a perpetrator of domestic violence. So the services that father was being asked to participate in, that were not directly related to his own, any own substance abuse, any own mental health, was to help him understand mother's condition so that he might be able to protect the children. So he might actually be able to have some sort of healthy co-parenting relationship with a mother who is very unfit.
Okay, so you're reading that finding is not actually the father having a diagnosed mental health condition, but that he needed counseling to help him understand like the whole dynamic that was taking place.
Yes.
Okay.
There are plenty of instances where there is a parent who is in a gray area or is even potentially unfit, and there is a fit parent, and the fit parent can still meet the minimum of acceptable parenting so that their rights do not need to be terminated, so that they don't need to lose custody of their child, but it requires them to understand the risks the child has in place and have some type of system to protect that child. And that's what the department was trying to do, and that's what the court was noting that father didn't do. Father was instead putting his head in the sand, saying, oh no, mom's fine. There's no problem at all. Well, as she tested positive during the trial, as she continued to visit with and interact with and maintain relationships with her abusers and abuse victim. And that is the action on father's part that would put the child at risk, and that father made it very clear throughout the trial was not something that was going to go away, that would proceed indefinitely, such that termination of his parental rights was in the child's best interest. I see my time is winding down, and so I would ask that this court affirm.
Thank you.
Thank you.
Ms. O'Sullivan.
Good morning, Your Honors. I'm Attorney Pam O'Sullivan, and I represent the appellee child in this matter. And we are seeking that the decision of the trial court be affirmed. To pick up where
Move that microphone closer to you.
Sorry, is that better?
Yes. Thank you.
I did want to inform the court of a summary decision that just issued in December of 2025 that involves the mother on this appeal. Mother had appealed the decree terminating her parental rights with regard to 2 other children. And that decision issued as the adoption of Adrian, 24P 1056, and on Friday, the SJC denied further appellate review. The trial in that matter ended in October of 2024. The decision of the trial court issued in November of '24, and then the current trial for this case began 4 months later in February of 2025. So I think that that case could offer some guidance to the court and some relevant information with regard to the history with Mother and her 2 former abusive partners who were part of that case. I think in this matter, Your Honor, I was trial attorney for the children in this case. I was also trial attorney for the children in the adoption of Adrian matter as well, that on the first day of trial, the motion to withdraw, I will see if I can find it in my extensive record and supplement it to the court, but it was very bare bones. There was the only reason that was offered by Mother's attorney at the time was that Mother asked that I file this motion to withdraw. That was the only reason given at the time. She did not offer any further explanation as to why Mother
Okay,
asked
well,
her.
that's a significant point. Okay.
And then when, at that point, the trial judge was well within his sound discretion to deny the motion to withdraw, and it was a trial tactic that Mother had employed in her previous trial, as well as this trial, is to ask that her lawyer withdraw on the first day of trial. So the trial judge also was the same in both cases. So that was denied because the Mother and her attorney failed to put forward good cause. That was part of asking a motion to withdraw, is that you have to the burden of proof is on the Mother to say, here's my good cause, Your Honor, for asking that my lawyer withdraw. That was not done. The requirement that some hearing happen to explore that, I think that Clemens, Kaufman, Carasetti all indicate that no, that hearing doesn't have to happen. What has to happen is the colloquy portion of it, that a person who wants to represent themselves is doing knowingly, voluntarily, intelligently, understanding the magnitude of taking on this, on representing themselves, that they're held to the same standard as any attorney would be held to. All of that was done. Mother indicated that she felt that her reasoning was that her lawyer was not handling her case appropriately. That is not good cause. I think that her motion to withdraw was properly allowed, and that Mother went on to represent herself knowingly. With regard to Father, I do think it's the same concern, is that he was very adamant during the trial, testified numerous times that Mother was a good mother. She had no issues. He could not recognize. He lacked complete insight that Mother's unfitness. I think the record and the lack of challenge to any of the findings by the trial judge supports that Mother is unfit, and that Father lacks the ability to see that unfitness and to be able to protect the child from any future harm by the Mother, and even by Father, because of his lack of insight into that. And the case law is clear that we don't have to wait for a disaster to happen to terminate rights here. That would be the case of Bruce. The care and protection of Bruce is that, that looking at this is that Father could not meet the needs of the child because he was putting Mother's needs before the child's needs. And if anyone, I'm almost out of time. If there's any questions.
Thank you. Thank you all.
Thank
We'll take it under advisement. Our last case is 25P 1048, Forefront Advisors versus Mass Alternative Care. Is welcome.
Good afternoon, Your Honors. May it please the court, my name is Kelsey Walkup, here on behalf of Mass Alternative Care. Massachusetts Alternative Care is requesting that this court reverse the denial of the lower court's, the lower court's denial of our motion to dismiss. Excuse me. There are several issues that I would like to address during this argument. First, was the motion to dismiss properly denied given the nature of the underlying arbitration award? Evidently, it is in dispute whether that was a final or interlocutory award, and our position is that it was not final because there remain issues that were unresolved that will impact.
But why was the panel asked not to address the interpretation of the agreement as to
the addendum?
The commercial unreasonableness.
At the time of the arbitration, the only issue that was put to the panel was regarding the calculation and whether those fees
I know, I'm asking why.
At the time, why was it reserved?
Why was it carved out?
At the time, the council elected to only proceed regarding that specific question. And I believe that it was bifurcated because there was no need to reach the issue of commercial reasonableness if the first question was not, until that first question was addressed. So rather than address both whether the fees were owed and if those fees were commercially reasonable, the issue of commercial reasonableness was not presented to the arbitration panel.
So the arbitration panel labeled it final award.
They did.
And we're supposed to ignore that.
No, the final order incorporated the interim decision by reference, and in that interim decision said that these claims regarding commercial reasonableness are specifically not being addressed by the panel, no evidence is being presented, and no arguments are being made. Those claims are reserved to the parties. And because our position is that the issue of commercial reasonableness may impact the final amount of the judgment, that in itself makes it.
Why not wait and have your second arbitration about the commercial reasonableness, and then if it affects this judgment, then seek a modification?
Because I believe that the entry of the judgment, the confirmation of the arbitration award as a judgment prejudices my client because now they have this judgment out there against them.
You didn't move to vacate or modify, and it's just the Superior Court shall confirm.
Shall confirm an award, and the award being, I believe, subject to interpretation as what is a final award. A final award shall be confirmed.
The panel thought it was final. They labeled it final.
They labeled it final, but Your Honor, you can put lipstick on a pig and call it whatever you want, but I believe that the language of the arbitration award and the reservation of the claims and arguments in that award.
What stopped you from moving to modify or vacate that and avoid the issue of it being called final?
Because I believe under Section 251, Section 12, and Section 13 that provide the bases for a vacation or modification of the arbitration award, the Mass Alternative Care's position does not fall under any of those bases. There's no allegation of corruption, fraud, that they exceeded the powers, that the arbitration panel exceeded the powers afforded to them, that the award was miscalculated, that the award was made on a matter that was not submitted to the panel. None of those bases are being.
Judge Allen's first question, I mean, you chose to bifurcate this. Why should you be relieved of that choice?
I don't believe that the bifurcation, that having it bifurcated impacts, I don't believe that it impacts the finality. I think it's that by bifurcating, it was keeping the costs of arbitration low for the parties. It is using the best resources of everybody's time. And there's no reason for the arbitration panel to address that issue at that time if they haven't gotten that far. So I think that was a choice of counsel at the arbitration, and I don't believe that it should, prejudice the defendant or negatively impact them given the entry with an entry of judgment.
Do you agree that the modifications that can be made under the addendum are all prospective?
I'm sorry?
That they're all prospective?
Yes. I'm sorry, and to go on to the University of Notre Dame v. TGAC.
Before you get there, just to walk through this for a second, I'm just trying to understand what happened here. If, let's say we were to affirm, and then you go back before the arbitrator, and the arbitrator says, well, now upon hearing all the evidence, it appears that what's commercially reasonable is only $1 million. What happens then?
If you affirm the dismissal, then I believe we move to modify the award, the judgment.
So you're saying you would not be without a remedy should the arbitrator in the future say, in other words, it just seems to me that it was odd that it was bifurcated for a certain, and it was a request for a judgment of a certain amount. In other words, not just liability. That if the first arbitration is just to establish whether or not there's liability here for breach of contract, yes. All right. Now we'll go into to find out, okay, what's commercially reasonable. But if the answer was no, then okay, there's no need to have that second hearing, so I can see why you're saving money in approaching it that way. But there was a money amount that was determined by the arbitrator, and it would seem that the judge was required to affirm that or confirm it as to be okay.
Right, and I think that goes to the Boston Teachers Union versus the School Committee of Boston case that was cited, and that the purpose of confirming the ARB award is to allow for the collection of an unsatisfied judgment. And it's our position that at this point, because that award is subject to modification, that it should not be collectible. Further, I think that as those, I'm sorry, that back to the finality of the award, that the arbitration is final when it reflects that the arbitrator's intent was to resolve all of the claims that were submitted for arbitration. The award clearly reserves some of those claims to the parties.
That was the issue that was sought in the arbitration. What if the parties decided not to go forward on the commercial reasonableness? Then what, are we just left with an order under your argument? Then what happens?
If the parties elected not to proceed with an arbitration on the commercially reasonable, well, I think it's purely speculative because the arbitration is proceeding in Arizona.
Yes, my question is speculative. So what would happen if that happened?
If it did
If
not
the parties
proceed,
decided not to go forward, say they both said, no, we don't have enough money, we can't pay counsel, we're not going to do it. What happens to the award? Is it not final?
I believe that then would require the arbitration panel to acknowledge that because the claims are being reserved.
By doing what? Making it final?
I'm sorry?
By doing what? Making it final?
By noting that those claims and arguments are being dispatched, that they're not being reserved by the parties are foregoing those arguments, and that this is the final award. I think that the reservation of those arguments and those claims to the parties leaves a question mark lingering.
So your brief does not cite any authority, it doesn't have any cases. Do you have any case for us to support your argument?
I believe that the two cases that were cited by my brother, the University of Notre Dame versus TGAC Waterloo case, is supportive of the position that this arbitration award is not final because it does not resolve all of the claims that were posed to the arbitration panel for one reason or the other, and the other being the Boston Teachers Union versus School Committee of Boston case, which held that the confirmation of the arbitration award was to allow for the collection of an unsatisfied judgment, and our position again being that is not yet collectible due to those remaining issues that are pending. We do acknowledge that we did not move to vacate or modify the award, and again, I don't believe that there is a good faith basis for Mass Alternative Care to vacate the award given the bases outlined in the statute. I think that the basis that we are articulating for challenging the arbitration award does not fall under those outlined in the statute.
Does commercial reasonableness even apply to a for-profit operation?
Your Honor, I'm not sure, and I don't have any involvement with the underlying arbitration, exclusively the entry of the arbitration award.
Well, your brother says that it does not, and that it only permits you to renegotiate going forward, which I think is what Justice Allen touched on earlier. So it's not going to affect this case.
I believe that's an
That's
issue
true.
for the panel to resolve. It has been put to the panel.
That it won't affect this case.
No, that whether it does or it does not is for the panel to resolve.
No, my question is, if it does not apply to for-profit operations, it will not affect this case.
If it does not apply to for-profit and does not affect this case, I don't have any reason to disagree with that, but again, I think that that is for the panel to resolve the issue. If there's no additional questions, I'll rest on my argument.
Thank you. Mr. Braddock. Welcome to the Commonwealth. I'm glad you got to see some beautiful New England weather while you're here.
Thank you, Judge Meade. May it please the court. My name is Corey Braddock. I am from Phoenix and was surprised to find myself yesterday in the middle of Indianapolis due to a flight diversion. And so I'm a little tired. I want to start by making something really clear. There was no bifurcation. And what we're seeing here before this court is an effort and an attempt to transmute language used by the panel into something that it's not. We tried to transmute a final award, all bold, top of the page, in the footer, to an interlocutory appeal, but this panel didn't retain jurisdiction to decide a darn thing. What they did do, and how this came about as the person who tried the underlying case and who is the lawyer trying the new arbitration, is they showed up on the first day of the hearing with a new legal theory. And the legal theory was, we can't have the arbitration today because we've got this addendum. And the party said the addendum doesn't apply because it applies to nonprofit compliance. And I want you to notice in the appeal brief, every time they refer to that, they don't refer to it, what the actual language is. The actual language in the addendum, it says, licensee will have the option to reassess the terms of the agreement to safeguard the licensee's compliance with the Massachusetts Department of Public Health guidance for registered marijuana dispensaries for nonprofit compliance, comma, namely to ensure the ongoing payments do not exceed fair market value and remain commercially reasonable. The reason that's important is because this lawsuit started when the parties entered a contract in 2015. And in 2015, there was no such thing as adult use cannabis. It was governed by an entirely different regulatory body than it is today. This addendum was entered into before the final regulations themselves were entered. And so it was anticipatory of the concept that what if, as the laws are developed, we learned that this contract would pay too much for a nonprofit business. And that issue was obviated when the law changed in 2017. It was a big deal here. And as they started to offer adult use, Mass Alternative Care elected to become a for-profit entity. So they have never operated a cannabis dispensary in the Commonwealth as a nonprofit entity, not for a single day. So to get to the meat of Judge Allen's question, isn't this prospective? And they affirmed that it was. Well, this court, one of the things the judgment gave us, and this was critical, is they didn't want to decide on expert testimony. How do we account for damages for the next 5 years in the case of one dispensary and for the next 6 years in the other dispensary? Because we get 10 years. The judgment says we continue to get paid a percentage of the revenue until the end of the contract term as it was entered in 2015. And so the only application it could theoretically have would be to address that issue of go-forward payments. They are again in breach of the agreement. They're not providing their sales figures for us to invoice. We're entitled to that money. So why are we here? We're here because in Massachusetts, as you know, there's an automatic stay that happens when somebody files an appeal. And when somebody owes you $4.5 million and it's an all-cash business, hard to account for, you just need time, right? You want time because you don't want to turn the money over. And so we're here to ask you to do the only real option you have, which is to affirm the judgment. They don't have a legal basis. In arbitration, it is the Wild West. You're all former practicing lawyers, and you know exactly how this works, and I see it all the time. What you do when you get an award and you're the loser, and you think there's this issue that you have, the first step would have been to file a motion for reconsideration. Hey, we really need this commercial reasonableness. What happened is the arbitration panel didn't want to deal with something. They didn't want to put off arbitration when everybody had flown from Massachusetts to my office in Phoenix, a lot drier, and they just didn't want to go through it. So they just kind of punted the issue after the parties discussed, this is for nonprofits, it's not a nonprofit. So if they had any application, and they are in arbitration, and this goes to the lack of interlocutory nature, this case, and this is why it's different than the Notre Dame case, it did go back to the same arbitration panel. In fact, we suggested as a cost-saving matter, and we're the ones that get the $4.5 million, and we're the ones that got a $400,000 attorney's fee in the first instance. We said, let's save time and money, and let's put it in front of the same panel. That's what we said in arbitration, and they objected. Because what do they want? They don't actually want the issue decided on the merits. They just want delay. And that's what they get when they file an appeal. If this state were, if the Commonwealth, if the Commonwealth were like other states, they'd have to post a supersedeas bond, and we would love it, because now we know we're going to collect on the judgment. You know, cannabis business is unique because of its intertwining or its inability to intertwine with the federal law when it comes to bankruptcy protection, not available to them. We'll be heading down the road towards a court-appointed receiver. But this issue is resolved. They didn't seek to vacate the judgment. The judgment would be, and even under the standard under the Commonwealth law, is if the panel had manifestly disregarded the law. They could say, oh, well, this is, you know, this isn't actually final because the panel has not addressed an issue. Well, there's not a trial in the world that happens where all issues are ultimately resolved. It just doesn't happen. And in here, I think what I've disappointed to hear is a suggestion that this was a bifurcated case. It was not. The issue at arbitration that was so central and that all the panel wanted to talk about and all the respondents in the arbitration wanted to talk about was whether adult use recreational cannabis was under a contract that started before it was ever legal. That was the issue that everybody was dealing with. Experts opined on the actual damages. That's what the panel awarded. That's what the court confirmed. The panel said, future damages are too uncertain. They're still required. They entered a specific performance order, and the judge confirmed it, that they have to pay 4.5% ongoing through the term of the contract. And that's the only potential applicability.
How do we characterize the request then not to respond to commercial reasonableness at the arbitration?
How are we responding to it?
No, how should we characterize it if it's not a bifurcation?
Well, I actually think this court should hold, by reading the language in the addendum, that it doesn't apply to a for-profit entity. That this right, the right of the appellant is only for, as the title sentence reads.
Of course, we can't do that because the parties agreed to arbitrate that, right?
I think the court can issue a ruling that generally says that the nonprofit law in Massachusetts is different than the for-profit law. I do think that that ultimate interpretation would be reserved for an arbitration panel. And let me tell you what, in the arbitration is kind of interesting to me, because we've already had argument on a motion to dismiss that they haven't put forth. At this point, we've got a panel of 3 arbitrators. We've filed a motion to dismiss, and the argument there is the same one that doesn't apply. But when they filed the motion, they didn't say it was to determine the commercial reasonableness. They said the purpose of their arbitration was to vacate or modify the existing or the prior AAA award and the court judgment, which the arbitration panel clearly can't do, which is why we filed the motion to dismiss. And that's the status of the underlying case. And I'm happy to address any questions the panel has or otherwise let you guys enjoy lunch, which you richly deserve.
Anything? Seeing none, thank you. Thank you both. We'll take it under advisement. That'll bring to close today's session. I'd like to thank our court staff, our clerk's office, my panel, the court officers, and the